So next up, we've got 3 different sections which relate to confidentiality in different formats. First up, we've got Abby Healey, a Managing Associate in our Reputation Protection and Media Litigation team, who's going to talk about how to keep proceedings confidential.
Thanks, Clarissa. I'm not quite going to be talking about keeping proceedings confidential, but keeping information used in those proceedings confidential. And this issue may arise either because you want to rely on your confidential information yourself in bringing or defending a claim, or because you are obliged to disclose it in the proceedings. Now, the CPR has some built-in protections, particularly concerning collateral use of information that you obtain in proceedings. I'll come on to look at that at the end, but really the focus of this talk is going to be about what other restrictions you may be able to put in place to protect your confidential information. And those restrictions are likely to arise at 2 stages. Firstly, in respect of the disclosure process, and secondly, in respect of hearings, both during and after those hearings. If case law in this area teaches us one thing, it's that each case has to be decided on its own merits. Even if you can satisfy the court that there is confidential information that needs to be protected, the restrictions that the court is happy to put in place are going to depend on all of the circumstances of the case. But before I move on to talk about some of those restrictions, I should just mention arbitration very briefly, only to say that hearings in respect to in arbitration proceedings, as opposed to litigation, are normally held in private. So at the contract negotiation stage, if you think it's likely that a dispute might arise which will involve your confidential information, you may want to consider inserting an arbitration clause into that contract. So firstly, the statements of case stage. What happens if you want to rely on confidential information in pleading your case? Bear in mind that CPR 5.4c allows a non-party to proceedings to obtain from the court file a copy of all statements of case. That does not extend to exhibits or attachments to the statements of case. So one thing to consider is, if you want to rely on confidential information, putting that in a confidential schedule, which you provide to the other side, but would not be obtainable by a non-party from the court file. The court file becomes accessible after the defendant has either acknowledged service or entered their defence. So again, just bear that in mind, particularly if you're a defendant. As soon as you file your defence, then that can be accessible by non-parties. And likewise, if you're the claimant, you may think you can file it and everybody's happy because no one's going to be able to see that. As soon as the defence is on the file or the defendant acknowledges service, then anyone can get access to that. You're likely to only want to consider pleading confidential information if it's necessary for you to do so in order to bring or defend a claim. Consider what the issue is concerning that confidential information. Is it so confidential that your opponent cannot see it? Or is the issue that your opponent can see it, but you have a problem with the public at large seeing it? If it's the case that you're happy with an opponent seeing it, then you're likely to want to put in place, before you serve those proceedings or serve your defence, you're likely to want to put in place undertakings. But again, belt and braces approach, you're likely to want to put that information in the schedule and think about getting the other party to sign up to those undertakings before you provide a copy of that schedule to them. If the issue is with non-parties seeing it, then there are other protections that you can put in place besides putting it in a confidential schedule. And again, belt and braces approach, we would probably always advise you to consider making an application to either have the court file sealed or for there to be restrictions put in place as to who can apply for copies of documents on the court file. For instance, you may be able to apply for an order that no one can obtain a copy without making an application on notice to the parties, so you have the argument at that stage rather than earlier on. I put beware CPR 31.14. This provision provides a party to inspect documents that are referred to in a statement of case. So don't think that you can prevent your opponent from obtaining your confidential information if you just refer to a document in broad terms but don't refer to the confidential detail within it. I would say 10 times out of 10 you're going to get a request pursuant to 3114 for inspection of that document. If there's absolutely no way that you can avoid it at the same time as you serve that pleading, I would recommend that you flag the issue with the other side and say that inspection will be withheld, and then you're likely to have an argument further down the line. So looking now at the forms of controls over the disclosure process, one such possibility is to put in place a confidentiality ring, or confidentiality club, as they are often called. Now, this often leads to some argument as to who is going to be within the confidentiality club. Yes, ordinarily parties would have no problem at all with solicitors and counsel of the opposing party seeing it, but to what extent are you happy to let the other side in person see it? Now, the norm is that you cannot go to a substantive trial without the party on the other side having seen all of the evidence on which you intend to rely on at the trial. I've put the case of Niche Products and McDermott up here. This is a case on which we acted for the defendant, and this was, unfortunately, it was unreported, but I thought I would talk about it because it's a recent case that highlights this issue. We already had in place a confidentiality club which restricted information only to the claimant's solicitors and counsel. The issue arose, though, in April as to what extent the experts on the other side could see our client's confidential information. It was all to do with trade secrets and our client's secret formula for its product. Our client's expert wanted to rely on the formula. Other side's expert hadn't got access to it. And so the court had to determine whether the other side's expert should be entitled to see it. Well, the court held not in this instance, which was extremely unusual. The main point being that the claimant chose to instruct an in-house expert. And so the court held that essentially by giving it to the other side's expert, you would be giving it to the side's party, which was what the confidentiality club had been put in place to prevent. Confidentiality rings ordinarily, as I said already, you cannot go to a trial of a substantive issues without the other parties to those proceedings having access to the evidence on which you intend to rely. The leading authority on this is the Al-Rawi case there, in which Lord Dyson commented that he was not aware, and this is 2012, not aware of any case where that had happened. That was confirmed in the Aeroflot and Berezovsky case, which took place in January of this year. We acted for Berezovsky's daughter, Ekaterina, in what was a battle over who was to control Mr. Berezovsky's estate. And Ms. Berezovskaya wanted to rely on confidential information. The information was not hers to rely on, it was a third party who objected to the other party in this Aeroflot seeing that confidential information. That party is called the Arkady Patakatsishvili family, or AP family for short, and they had argued that they didn't want Aeroflot to see the information because of the risk that it would end up in Russia and end up in Putin's hands. Now, when that case came before Morgan in January of this year, he said that in his judgment that he had asked around, and particularly in the IP courts where this issue tends to arise time and time again, and he again was not aware of any case which had gone to trial where the other side had been prevented from seeing confidential information. In that case, he said that Aeroflot had to see that information in order for the substantive issues to be tried, but he said that he was prepared to put in place restrictions. And in that case, the restrictions were that certain members of Aeroflot who were responsible for giving instructions had to be able to see it, but they could only be provided with one single hard copy and they could not make any further copies. The court may, though, put in place other restrictions, such as that you do not get physical control of a copy, you have to go and inspect it at a solicitor's office. or there was one issue in the Berezovsky case about the extent to which that information could leave this country and go to Russia. So, as I said at the start, the court will look at all of the circumstances when deciding what controls to put in place. A consequence of non-compliance with an order in this area is contempt. So even if, in the unlikely event that you are able to agree a confidentiality club with the other side, then make sure that is documented by way of court order. And finally, just before I move on to talk about hearings, just bear in mind what your obligations are under CPR 31. If the confidential information isn't something that's relevant to the case, you can redact it. So even if that is in a document which would otherwise be disclosable, then consider the extent to which you can redact and avoid having to think about what other protective measures can be put in place. So hearings, the general common law principle is that hearings take place in public and judgments and orders are public. This is also repeated in Article 6.1 of the European Convention on Human Rights, which says again that hearings and information about hearings must be publicly available unless there is a reason why it is in the interest of justice to prevent that from happening. One such exception is embedded in the CPR, and that's CPR 39.23, which allows for hearings not to be held in public if those hearings talk about confidential information and publicity would damage that confidentiality. Just bear in mind, though, that even if you can establish to the court's satisfaction that that is the case, the court is still likely to want to sit in public as much as possible. That may well be sitting in public and breaking out into private, or it may well be sitting in public completely and talking about the confidential information in such vague terms that it's not necessary to go into private. And certainly that happened throughout the whole of the Berezovsky hearing. We talked about the confidential information, and the hearing was completely in open court, and Aeroflot didn't know what the information was that we were arguing about. The court may also consider other alternative orders, such as, for example, an anonymity order. So that still allows the hearing to take place in public and for publication of the judgment and orders, but it would just anonymise the names of one or more of the parties. If you're considering that, though, just bear in mind about the information that is contained in publicly available documents. Is it possible to work out who the parties are from that? If so, then that's probably not going to be sufficient protection. Just because a hearing takes place in private, I would just say that that doesn't necessarily mean that it follows that there will be no publication of the judgment or of the order. The two issues are completely separate. So that's something that you would want to consider and make representations to the judge about at the time of your substantive hearing. And just one final slide, just as I mentioned at the beginning, restrictions on collateral use of information obtained in the proceedings. I've set them out, the provisions out there for witness statements and disclosure of documents, so I won't repeat them. I will just mention, though, that one case that was reported only about 3 weeks ago, a Court of Appeal decision of IG Index and Cloete, that's CLOETE, and the Court of Appeal confirmed in that case that when deciding whether a party can use information which has come into its hands in the case throughout proceedings, then the court has to consider the overriding objective and dealing with cases justly. And in that case, the Court of Appeal actually allowed the company IG Index retrospective permission to rely on information that had come into its hands in employment tribunal proceedings. Thanks very much. Only slightly over.
I've had a Court of Appeal hearing where we had to troop out every so often for discussions about confidential information because it was held that the hearing had to be in public, but the confidential information was so confidential that even my client had to move out when the actual discussions about it went on.